Uh, Thank you, Kiki. I was just about to let everybody know, yeah, we are recording these lunch and learns so that they can be available as a resource to members. You can find all of them on our website. So welcome and thank you all for coming today. For anybody who this is your first EBHO event, EBHO is a mission and member-driven organization founded 41 years ago in Oakland. Our mission is to mobilize the power and wisdom of our members to produce, preserve, and protect affordable housing opportunities for low-income communities in the East Bay. Our membership spans individuals who care about affordable housing, some residents of affordable housing, some former residents of affordable housing, some of us with friends and family or neighbors that we care about who could benefit from affordable housing. And then also organizational members, service providers, nonprofit affordable housing developers, other advocacy organizations. And we are a wide tent with room for everyone who cares about the future of housing and affordability in the Bay Area. So if you're not already an EBHO member, we invite you to join us. We invite you to become a member. Lavender Briscoe, our membership associate, is here with us on the call. You can drop a note in the chat to let us know you are interested in becoming a member. These Lunch and Learn series began a year ago in 2024 as part of our 40th anniversary celebration to celebrate how EBHO started, which was a group of folks meeting around brown bag lunches to talk about affordable housing issues in Oakland and how we could advance an affordable housing agenda. And we've come a long, long way from there. But a critical part of our mission is still education and empowering community members with events like these. So we're excited to be continuing this Lunch and Learn series to see more about future Lunch and Learns that we have planned or RSVP. You can visit our website. I believe a link is being put in the chat right now to see about other Lunch and Learns we have coming up. Our next Lunch and Learn series is going to be, or our next Lunch and Learn event is going to be about digital organizing, and it's going to be led by our communications director, Kate Young. So thanks, Kate. We're looking forward to that. The only other announcement we have about things that aren't going on today is a reminder that EBHO's Faith and Justice Breakfast, which we are co-hosting with the Multi-Faith Action Coalition and the Faith Alliance for a Moral Economy, is taking place next week, 1 week from today, Thursday, August 28th, at the Unitarian Universalist Church in Walnut Creek. We invite everybody to RSVP. It is a ticketed event, but nobody will be turned away for lack of funds. We've been hosting the Faith and Justice Breakfast for a long time now as part of our work bringing faith communities together to advocate for affordable housing. So we hope to see you there. That is all of our announcements, and I want to let us dive in now to our Lunch and Learn. Today we are talking about the Surplus Land Act. This is a topic that EBHO has been working on with partners for a long time, advocating for strengthening the Surplus Land Act at the state level and doing monitoring and implementation work at the local level. As we go through the Lunch and Learn, if you have questions, please go ahead and put them in the chat. We will circle back to all of them. We'll collect any questions that come up and we will address them at the end of the webinar. So don't think they're going unanswered. We are collecting them and we will respond to them. With that, I want to introduce our panelists today. We have Jeff Levin, who is the Senior Director of Policy at EBHO. Jeff works on a range of policy issues for EBHO. He's been here since 2013. He covers housing elements, land use planning, state legislation, equitable and sustainable development issues, affordable housing funding, and of course, public land. For many years, Jeff has worked with partner organizations to draft and lobby for changes to the Surplus Land Act. Prior to joining EBHO's staff, Jeff worked for nearly 30 years in the City of Oakland's Department of Housing and Community Development. And with Jeff today, we have Tahirah Dean. Tahirah joined Public Advocates Metropolitan Equity Team. Tahirah joined Public Advocates Metropolitan Equity Team as a staff attorney in November of 2023. She works with coalitions to build power in the housing policy sector, advocating for more affordable housing and equitable land use policies. Tahirah brings with her a breadth of experience in the housing justice space, having worked at Legal Aid of Marin as an eviction defense attorney for several years. Prior to that, she worked with immigrants on solutions to live and work in the U.S. in the private sector. So thanks everybody for being here, and with that, I'll turn it over to Jeff and Tahirah.
Great, thank you. Good afternoon, everybody. It's nice to see so many folks here, and we are delighted to be able to do a deeper dive into the Surplus Land Act. Before we start with the full presentation, I just want to tell you a little story. The picture that you are seeing on the display now is the famous East 12th Street remainder parcel in Oakland at the bottom end of Lake Merritt. About a dozen years ago, maybe a little more, the city of Oakland, without any public solicitation process at all, entered into an agreement with a private developer to build a large, entirely market rate project on this site. And when the developer started talking with the neighborhood, there was a huge outcry about the size of the project, having a large high-end project at the edge of a neighborhood that was already experiencing a lot of gentrification and displacement pressures and the complete lack of affordable housing. We had done some work on the Surplus Land Act already, and we were at a meeting and said to folks, look, it looks like the city has not complied with the Surplus Land Act here, and that sparked a flurry of activism that actually included a brief takeover of a city council meeting. Eventually, a memo from the city attorney, confidential memo, got leaked to the press in which the city attorney admitted that the city had not complied with the Surplus Land Act, and the city had to go back and start the process all over again. And this time, while they selected the same developer, they had to do so in partner with an affordable housing developer who was providing the required minimum of 25% affordable housing. That wasn't exactly the outcome that the neighborhood was seeking, although it was an improvement. And things went forward for several years, but the market rate developer was never able to line up the financing for their portion of the project. And after multiple renewals of the negotiating agreement, the city finally dropped the developer, gave half the parcel to the first nonprofit to build affordable housing, and gave the second half of the parcel to the nonprofit developer that the community had been working with on their own community-based proposal. And so today we are now looking at 200% affordable housing projects that will be developed on this land. This is kind of the poster child for the SLA because it was the neighborhood's campaign around public land for public good that really brought the SLA to the attention of a lot of people. So we just wanted to highlight that before we jump into the presentation. Next slide, please. So we want to start just with an overview and some definitions. The Surplus Land Act, which has been around for a long time, I think going back to 1969 or 1970 and amended several times, appears in the government code at section 54220. There have been a number of amendments, but the two major ones were AB 1482 in 2019, which put some real teeth into the SLA, giving the State Department of Housing and Community Development oversight of the process and adding financial penalties for violations of the act. And then a couple years ago, a pair of bills, AB 480 and SB 747, made a number of changes, in particular adding a number of exemptions and streamlining some of the process for declaring land to be exempt surplus. And we'll talk about that, particularly where the local agency is intending to do affordable housing from the get-go and making it easier for them to do that. The basic concept in the Surplus Land Act is that public land should be used for public good. So specifically, before disposing of any surplus land, a local agency must first offer that land for park and open space, for schools, or for affordable housing. And when they get responses to that, affordable housing development must be prioritized over other uses on that land. And then there's some additional priorities for whoever has the largest amount of affordable housing. Next slide. So let's talk about what we mean by surplus land. First of all, before disposing of surplus land, meaning either to sell it or to lease it for more than 15 years, it must be declared by formal action at a public meeting of the legislative body of the local agency. So the city council, the board of supervisors, the board of directors, whatever that is, has to declare with written findings that the land is surplus and no longer necessary, not necessary for the local agency's use. And in fact, the agencies, with a few exceptions, cannot take any actions to dispose of land. So it's not just that they can't complete the deal, they can't issue an RFP or start talking to developers until they have gone through the process of declaring the land either surplus or exempt surplus. Next slide. So what do we mean by local agency? It's a broad term, and in fact, AB 1486 expanded this. Cities and counties, of course, are local agencies, also school districts, transit agencies, special districts, water districts, hospital districts, cemetery districts. We've actually played a big role in shaping some provisions here. And also the redevelopment successor agencies that took over the property previously owned by redevelopment agencies. All of these are considered local agencies and are covered by the SLA. Next slide. So, as I said, the provisions of the SLA say that an agency has to declare that the land is surplus and not needed for the agency's use. So what do we mean by agency's use? We mean that the land is either currently used or is planned to be used pursuant to a written plan adopted by the governing board for or in support of agency work or operations. So to qualify as agency use, the agency itself has to be using that land and using it, for its normal purposes. And there's an important distinction here. It has to be the agency itself that has used it. We have seen public agencies try to claim that using the land to promote economic development is use by the agency. But the law is pretty clear. There is a difference between agency use for its own work and the agency disposing of land to further the public purposes of the agency, which is a much broader term. And that latter one does not count as agency use. And the law is very clear that disposing of the land for commercial or industrial uses or activities is not agency use, and disposing of land for investment or to generate revenue to support the operations of the agency is also not considered agency's use, although there is an exception for special districts, and we can talk about that a little more. Next slide. So as I said, there is surplus land and exempt surplus land. At this point, there are now, I believe it's 19 separate exemptions defined in the law. Some of them fairly straightforward, some not. So small sites less than half an acre that are not contiguous to public land that's already being used for open space or low mod housing is not considered surplus land and can just be disposed of after it's declared as exempt. Certain kinds of transfers, if a public agency is exchanging its land with another public agency or exchanging land with a private entity for land that it is going to be using for its own use, then those transfers are also considered exempt surplus land. Essentially, there is land still remaining in public use at that point. Disposition of former streets or rights of way. So if a city has done a street alteration project and there's a small parcel of land left over, if they are transferring that land to an adjacent property owner, that's considered exempt. Land subject to valid restrictions not imposed by the agency itself, and that not imposed by the agency itself is really important. This includes things like airports where the federal government has limitations on putting residential land on airport land, lands that are dedicated in state trust for non-residential purposes. Those would be considered valid restrictions. Ordinances passed by the locality saying we're going to develop this land for some other purpose is not considered a valid restriction because it's imposed by the agency itself. And most importantly, voter initiatives reserving land and prohibiting the use of housing are also considered to be restrictions imposed by the agency itself. So a group of NIMBY neighbors cannot try and get a measure on the ballot and pass it restricting the use of public land and preventing the use for housing, and in particular for affordable housing. That would not be considered a valid restriction, and that would not be exempt surplus land. And finally, here I just want to non-residential zoning or land use designation, which is in the control of the local jurisdiction, does not make land exempt by definition. So while somebody looking to acquire the land would have to consider whether they would be able to get the zoning change, the jurisdiction cannot rely just on non-residential zoning to declare the land to be exempt surplus land. Next slide. And then there are some very specific kinds of exemptions called out. In particular, there are several exemptions that deal with situations where the land has been designated or is planned to be used in whole or in part for affordable housing, including to be used by community land trusts. And so there's various provisions that allow for declaration of surplus land as long as at least 25% of the housing developed on that site is affordable housing, and as long as certain density requirements are met on that land. There are also some very specific provisions called out exempting the Alameda Naval Air Station, which is already covered by a legal consent decree requiring 25% affordable housing. So the entire former base is considered to be exempt surplus land. Los Angeles has a provision covering program they have to use public land specifically for homeless, supportive, and permanent affordable housing. The city of Chula Vista for several decades has a big parcel of land that is covered by a long-term plan for a new college campus, along with housing and commercial uses. That has been called out as exempt, provided they provide a minimum number of housing units and that 25% of that housing be reserved for low-income folks. And finally, there are provisions for transit agencies to declare as much as their entire portfolio of land, as long as it is covered by either state law, as in the case of AB 2923, which governs BART's disposition of land, or an adopted plan for affordable housing, similar to what VTA in the South Bay or LA Metro down in Los Angeles have. So if the transit agency has a plan that in its entirety is going to make sure that at least 25% of the housing that they build on their land is going to be affordable housing, then they can declare all of those sites to be exempt surplus land, as long as they then follow through and actually do the 25%. They would be in violation if they don't. And lastly, there are exemptions for special districts who made the case that they sometimes need to lease out land for a very long period. It's land they're going to need in the future as a water district, as a cemetery district, that they wanted to be able to lease out and generate revenue without having to offer it for housing because they're going to need it in the future. So that is, on the one hand, it's defined as agency use, but they still have to actually go through the process of declaring that land to be exempt surplus land before they can move forward with that. Next slide. So let's talk quickly about the disposition steps, what triggers these requirements, what kind of notices are required, and what happens as people respond to them. Next slide. So the requirements kick in prior to disposing of or participating in negotiations. As I said, city agencies can't start talking to potential buyers until they have followed these steps. Some preliminary work, like getting appraisals and doing some environmental testing, is allowed, but nothing that actually looks like a move to enter into talks with a specific developer or solicit proposals, nor can they respond to unsolicited proposals that come in. There are exemptions, as I said. If an agency is looking to exempt the land because they're going to do affordable housing, then of course for that they can do an RFP before they declare the land exempt surplus, because they have to know they have an affordable housing deal before they can actually make that declaration. Next slide. The agencies then have to issue notices of availability to public agencies and to affordable housing developers who have registered with the state. Parks and recreational districts and school districts and public entities in infill opportunity zones all also have to receive these notices, but these are priority entities that have to be notified. Next slide. A list is maintained of these notices by the California Department of Housing and Community Development. Again, I've looked at all the places that need notices. The notices need to specify that what the agency will be considering is proposals that contain at least 25% housing for lower income households if somebody's proposing a housing use on the property. Next slide. Interested qualified entities have to notify the disposing agency. They have 60 days to respond and say, we are interested, and that will then kick off a negotiating period. Next slide for that. So as I said, affordable housing gets first priority over schools or parks. And if there are multiple proposals for affordable housing, then the proposal with the most affordable units, and then if there's a tie there, the proposal with the deepest level of affordability gets priority. But the agency may negotiate with all of the responding entities simultaneously before entering into a deal with someone. Next slide. So the agencies must negotiate in good faith for at least 90 days, which requires that they actually be serious, that they provide the required information, that they respond in a timely way. And I'm just going to add one note here because this came up once in Beverly Hills and we are dealing with this in Concord now. The state has been clear that if an agency goes out and solicits for affordable housing and has certain conditions that they place on that, and they don't get any offers, or more importantly, they get offers, negotiate, but don't come to a deal, and then are able to issue a new request for proposals for other uses, they cannot loosen the restrictions. So if they required certain things of the affordable housing developers, they have to require those same things when they put it out for more general use. And we're working through a case on that in Concord right now. They can put conditions on the land, but they cannot prohibit residential use as one of the conditions. They have to allow residential use. They cannot put conditions on the disposition that would reduce the maximum density or lot coverage below what is permitted by the zoning. And they cannot require additional design standards if they have any adverse impact on the viability or affordability. So a lot like some of the state streamlining provisions, the local agencies actually can't put conditions on this land that make it impossible to do what the zoning says can be done with it. Next slide. In terms of sales price or lease terms, the agencies are authorized to sell or lease at full market value, or they can sell or lease for less than full market value. They are not required to do so, but the law is very clear that they can write down the cost of the land, and that is not considered to be a gift of public funds. Next slide. So I'm going to stop here. We're going to turn it over to Tahirah to talk about what happens once those negotiations and solicitations are completed. Tahirah.
Great, thank you so much, Jeff. Hi, everyone. Once again, my name is Tahirah. I'm a staff attorney at Public Advocates. So yeah, at this stage, after negotiations, so you can go to the next slide because this is just an overview of the post-negotiation part of the SLA process. So yeah, after negotiations, the local agency has 30 days to dispose of the land and to give HCD the following. 1, a notice of availability, 2, any notices of interest, 3, a description of the negotiations, and 4, copies of the deed restrictions to be recorded. If the agency disposes of a land to an affordable housing entity that does not have first priority under the statute, it must provide an explanation why to HCD. Next slide. HCD will then review the information that was submitted and make a determination of compliance. If HCD finds a violation of the SLA, it must issue written findings within 30 days to be given to the agency. If HCD does not respond within 30 days, the sale or the lease can proceed. And so what happens when the local agency receives HCD's letter with findings of violations? Well, the agency has 60 days to respond. It can either A, correct the violations and explain how it will correct them, or B, explain why the agency's process does comply with the SLA. So basically arguing with HCD. And then HCD will do one of three things. Either they'll issue a determination letter finding the agency did correct the violation, or two, determine that the agency had actually proceeded correctly, or three, they'll issue an official notice of violation. When a local agency receives that notice of violation, they cannot dispose of the property until after they hold an open and public meeting to review and consider the substance of the notice of the violation. Or they can completely stop the process of the disposal of the land. Next slide. So if there were no violations found by HCD, the local agency may sell without further obligations under the Act, except if a site is subsequently developed as residential with 10 or more units, then at least 15% must be affordable to lower income. And they must record these restrictions for enforcement. Next slide. So what are the affordability restrictions? Under the SLA, the affordable housing entity must record a covenant on the property agreeing to make available at least 25% of the total number of units available at an affordable cost to lower income households for a specified period. Occupancy must be restricted to low income, that's less than 80% of AMI, and the rent charge cannot exceed 30% of 60% of the AMI. The affordable housing units must be made available at an affordable housing cost for a period of 55 years for rental housing, or 45 years for ownership housing, and 50 years for rental or ownership housing for tribal trust lands. Next slide. So there are financial penalties if an agency violates the SLA. But a completed sale or lease cannot be stopped once it goes through. But if an agency does proceed, they're not going to get away with that without any facing any penalties. So the first penalty for the first offense, it's 30% of the sales price or appraised value. And that is to be deposited into a local housing trust fund or other specified state funds. And if there's a subsequent offense, it's going to be 50% of the sales price or appraised value. Next slide. So are there different requirements for special districts? Yes. Districts other than transit districts may dispose of the land that is zoned to permit residential use if 15% of developments of 10 or more units are affordable to lower income households. And special districts will include, hospitals or cemeteries, for example. Transit agencies are not considered special districts. Next slide. And the question of, are some existing negotiations for disposition only subject to the pre-SLA, before there was an amendment to the SLA, so pre-AB 1486? Yes, projects with exclusive negotiating agreements, ENAs, including some former redevelopment agency properties, are exempt from the specific AB 1486 procedures. So if an agency entered into an ENA prior to September 20th, 2019, the disposition is subject to pre-AB 1486 law, provided the disposition is completed by December 31st, 2027. Similarly, property in the Community Redevelopment Property Trust Fund, subject to an ENA or legally binding disposition entered into no later than December 31st of 2020, is also subject to pre-AB 1486 law, if that disposition is completed by, once again, December 31st, 2027. Okay, next slide. So what happens to those misbehaving agencies that went through with a sale that violated the SLA? In addition to getting fined, there's some other enforcement options here. So HCD, the AG, and third parties are all authorized to enforce the SLA prior to disposition. We already talked about how HCD issues a notice of violation, but they can take it a step further and take legal action. As stated, they'll issue the notice of violation and determine if the responses are deficient. They'll notify the agency, and then they may notify, the AG to seek the enforcement. The suit may be brought at any time during the disposition process when the local agency has violated the SLA. Next slide. Okay, so the housing element has enabled more tracking of surplus land disposal. So that's another win for the housing element. In addition to reporting to HCD on the results of each notice of availability, cities and counties must inventory the sites they own and include an inventory of land with a description of any plans to dispose of their sites in the housing element, including how the city or county will comply with the SLA. And in their annual progress report to the Office of Planning and Research on Housing Element Implementation, they must list all the sites that they own that are either surplus land or land in excess of foreseeable needs, and all sites included in the housing element inventory that have been sold, leased, or otherwise disposed of via the Surplus Land Act. So housing element should be a great resource for us to, I know what's happening with surplus land properties. Next. So we have a lot of different references for you guys in terms, because I know it was high level, and it's the process is not so straightforward. So there are HCD guidelines. We're going to drop a bunch of links in here for you guys. The HCD guidelines are there. There's their dashboard where they keep track of these things. There's a FAQ and a flow chart that we worked in collaboration with EBHO and HELP. And so we're gonna flip to that flow chart right now to just do a little overview of that briefly. And you can find this on our website. So the first page of the flow chart, it just breaks down for anyone that's, any advocate that wants to, to see how they can turn surplus land into, potentially affordable housing. It tells them how to navigate to see if, what the process would be like to go through the Surplus Land Act process. And so this is an overview, and then it goes into the different pathways of either if land is declared surplus or if land is declared exempt surplus. The path ends at 2B for if the land is declared exempt surplus. But you can continue down if the land is declared surplus and see the different pathways for response times with HCD, whether or not there's been an agreement reached between parties that are interested in purchase or lease of the land. And then it goes down to a potential enforcement if there is violations found. And so, yeah, I think it's super helpful. It should be used also with the FAQ, which we dropped in the chat. Together, these two should be a good resource and great tools for you guys to be able to, navigate the complex world of Surplus Land Act. So that's it for my end. Passing it back to you guys at lunch.
Thank you so much, Jeff and Tahirah. Just making sure that's the end of the presentation. We're good for Q&A? Okay, awesome. Thank you guys so much. So we have a couple questions in the chat that I'll start with, and then we can open things up from there. The first question from Ginny Does this affect surplus land deals that were made years ago, but no work ever began? Ginny, I don't know if you have anything you want to add to that question, if there's anything in particular you were asking about. Otherwise, I'll let Jeff and Tahirah take a stab at it.
Well, I can give examples if you want me to. San Leandro has the marina shoreline, which they have sold to a developer 20 years ago. Nothing's ever begun. And that whole deal is still in question. It's literally been sitting. But they just recently did something where they sold off still a dirt road on the bay shore to a nearby business. And it was just part of the consent calendar they sold it for $1 so that the business would pave it. But it was like 2 miles long, would have been a perfect safe parking place. Off the road, totally invisible. And they did this secretly. Nobody knew about it until it got voted on in the consent calendar. So thanks for letting me talk.
Yeah. Ginny, we should probably talk offline because it depends very much on the specific circumstances. I think as we were going through, we noted that if a city had entered into an exclusive negotiating agreement prior to the passage of AB 1486 back in 2019, then they had an extended period in which they would fall under only the old provisions of the law and not the newer ones. And they have till the end of 2027 to complete those deals, so they would not yet be in violation. If they actually sold the land and transferred ownership back then, and the developer has still not done anything, that would not be a violation because the city actually transferred the land long ago. But if the land is still owned by the city, then that's something we could take a closer look at. So by all means, let's talk offline, look at the specifics, and we can see what might be done there.
There was also a question about FMR and if agencies are allowed to pay less or more, or sell the land for less or more than that, and if an appraisal is required.
I think the questioner meant fair market value. FMR is fair market rent. There is no requirement to sell the land. The law says they can sell the land for fair market value, or they can sell it for less than fair market value. There is no requirement for an appraisal, although, a lot of jurisdictions will get appraisals on the land to make sure they're getting as much money as they can, or, can value any write down and show it. But there's nothing to prohibit them from selling it at or below. And I don't think there's anything that would prohibit them from selling it, quote, above market value. Although, if it's an arm's length transaction between two unrelated parties and the buyer is willing to pay that much, that is essentially the fair market value.
Great. Jan, go ahead. I see you've got your hand up.
Yes, thanks. I'm curious if I heard this right. So with the housing element, if a city has to declare a parcel for, say, interim transitional living or something, or shelter of some sort, do they have to own the land? And either way, let's say they go through a housing element period and nothing ever happens, and no get any offers or whatever. Can they then change the specific reason for that lot to some other place, as long as they substitute the same transitional or living or what housing some other place? How long do they have to keep that parcel for the designated purpose that they stated in the housing element? That makes sense?
Well, so the housing element, like when I brought up the housing element, I just meant to note that any surplus land needs to be addressed in the housing element. And in regards to like what can be done with the land, that needs to go through that's like a separate thing of whether, it has to be determined surplus or exempt surplus. And then that's when the path of like how it's gonna get sold or leased is gonna go. So yeah, I'm not sure if I'm answering the question, but.
Okay, so sounds like, yeah, they're not committed to that during the 13 years or whatever the housing element is. They're just willing to work with someone if they want to develop it for that reason.
I mean, if they called out in the housing element that the land would be used for a specific purpose and they then use it for some other purpose or don't really follow through, I think, you would want to comment on that when the city does their annual progress report and possibly complain to the state that the jurisdiction is in violation of their housing element. But as far as the SLA is concerned, if they have designated land for some sort of interim use for the homeless, and that involves leasing the land to, a nonprofit provider, for example, for less than 15 years, leases of less than 15 years are not considered to be disposal, so they're really not covered by the SLA. So
Okay.
it's fine for an agency to just go ahead and lease the land for 5 or 10 years for some kind of interim use.
Similarly, if you have affordable housing that has been built and goes through the 55-year process, can that land then be used for something else? Can those units be repurposed or whatever?
Yeah, I mean, technically, if the land is disposed for affordable housing and they do a 55-year regulatory agreement at the end of the 55 years, the restrictions expire. I will tell you with 55-year restrictions, and particularly with nonprofit owners, what you're likely to see during those 55 years is that the entity needs to refinance the property to do improvements, and they'll end up with a new set of 55-year restrictions if they're funded by the state or local government. And so you sort of have to pay attention on an ongoing basis. Though we do have a problem that continues out there, particularly with for-profit entities that had entered into deals years ago that had 20 or 30-year terms, and they get to the end of those terms, and then they dispose of, convert the housing to market rate housing or to some other use altogether. And that's a serious preservation problem. I think we're going to see less of that with the kinds of folks that enter into 55-year agreements.
Okay, thanks.
There's a question about the Concord Naval Weapons Station, and that starts as the starting place, but then to more general questions, what size parcels do SLA restrictions apply to, and do requirements differ between horizontal and vertical developers?
Except for the exception for parcels less than half an acre sold to the adjacent property owner. So if there's a vacant lot next to a homeowner, the homeowner can buy that vacant lot, if it's a small piece of property, without going through the SLA. But otherwise, anything from, a half an acre up to thousands of acres is covered by the SLA. There is a set of exempt surplus land provisions tied to parcels of different size where there is going to be affordable housing. So there's one provision that applies if a parcel is less than 1 acre, and other provisions that kick in for larger parcels. The basic thing is if the jurisdiction, if an agency wants that disposition to be treated as exempt surplus land, then a couple of conditions have to be met. One is there has to be enough units on that land equal to 10 times the number of acres. So if you have a 150-acre parcel, there has to be 1,500 units of housing developed on that land. It can be concentrated on one part of the land, but that's the minimum amount of housing they have to build. And part two, 25% of those units have to be restricted as affordable housing for 55 years. If they meet both of those conditions, and usually if they also solicited development proposals that included all of the entities that registered as interested parties with the state, and they keep a whole list of these on the HCD website, as long as they've gone through those procedural requirements, they can treat that as exempt surplus land. But yeah, there's no sort of upper bound to what is covered by the SLA, small and large parcels.
Bill, you've got your hand up and that was your question if you want to follow up. But we can't hear you if you're talking right now.
Still not hearing you, Bill.
Bill, why don't we respond to the part about horizontal and vertical developers, and then if you can get your audio working in the meantime while Jeff and Tahirah are responding to that. Are there different requirements there?
Well, the SLA isn't so much concerned with what you're developing as how you dispose of the land. So if the agency is selling the land or they are leasing it for more than 15 years, generally speaking, that counts as disposition. There's one exclusion, which is if they lease the land for more than 15 years, but there's not going to be any real development taking place on the land. They're just going to continue the existing use. Think, for example, of piece of land that's leased for, I don't know, several decades to a museum. The lease expires, they want to do a new lease. They can do a lease for more than 15 years as long as there isn't going to be a bunch of new development work taking place. But there's no distinction about whether, the recipient of the land is doing, just horizontal development, preparing the site, or vertical development with actual buildings being constructed on it. It's really about disposing of the land in the first place. The whole idea here is if an agency has land that they don't need, this is public land. It's a public resource and it should be used for public good. That is, the core concept here is public land for public good. And the highest priority use for that is that it should be used in whole or in part for affordable housing. And that's sort of the core principle that we advocate around all the time, is that public land needs to be used for public good. It's hard enough for affordable housing developers to get hold of privately owned land. And whenever the housing market gets heated, they have a really hard time competing with private developers to acquire land. And that's why we want to prioritize public land for that purpose.
Bill, let's see if your audio is working at this point. Oh yeah, we got you.
We're good.
Yeah. Okay, go ahead. The point of my question was, I saw one plan that basically had large neighborhoods of Concord Naval Weapons Station were all market rate housing, and they had all of the mostly affordable housing then located near the transit stations. So there's reasons for that, but I just wondered if the Surplus Land Act was something you'd have to consider with that kind of development.
As long as 25% of the housing units are affordable, they can concentrate the housing itself and the affordable housing anywhere on that land that they choose. And I think, as you know, EBHO has campaigned for over a decade around development at Concord Naval Weapons Station. And apart from the Surplus Land Act, we, have gotten the city to commit to doing 25% affordable housing out there. It's in the specific plan for the area. We're continuing to advocate. And frankly, I think we're kind of happy to see that they're building the affordable housing close to transit, because those households are probably going to be transit dependent. And so from our standpoint, it actually makes a lot of sense that they're doing it that way. There are financial reasons for developing the affordable housing as separate 100% projects. It's far easier to secure financing that way, and you can get projects with much deeper affordability than if you just required the market rate developer to include, 20–25% of the units in their market rate project. Those units would probably be right at the very top of what's defined as affordable. In the 100% projects, you'll get a range, including stuff affordable to, people at extremely or acutely low income levels.
Right. Then I had one comment you mentioned earlier about expiring, the Surplus Land Act expiring. We had an example of that when I lived in the city of Alameda. You may remember the housing, the Coast Guard housing there. It was, we wanted to have it procured for reuse as affordable housing, but we couldn't do it. Excuse me, there wasn't a Coast Guard housing. It was a, I can't remember the name of the development now, but there was a big private apartment complex there. And so that wasn't, never mind, that wasn't surplus land, so
Okay.
got mixed up.
Two more questions about specific types of agencies. One question, can cities work with school districts to make their surplus land available for affordable housing development? And another question, have we engaged in advocacy around Caltrans land being included in the Surplus Land Act, with the understanding being they have more land that could be surplus than any other state agency, but are largely claiming that it's exempt. So school districts and Caltrans.
Okay. Let me start with the second one. State land is not covered by the Surplus Land Act. There are separate laws and rules about disposition of state-owned land that would cover Caltrans. I'll just editorialize and say that Caltrans has been particularly difficult for people to deal with. They are in fact sitting on a lot of land that we would like to see disposed of. Tahirah, I don't know if you want to add anything to that before we come back to the other question.
Yeah, it was there was someone from one group that was trying to look into how to deal with Caltran and see, you know, how they could be able to use some of that land, because they are sitting on it. But I haven't heard anything further on her attempts to try to get like a consistent working group together. But that's definitely on some advocates' mind about, you know, trying to work with Caltrans to push them on that for sure.
Yeah, so people may remember that Governor Newsom actually issued an executive order to state departments to identify and dispose of surplus land for housing. This isn't something we have followed nearly as closely, but you know, it's handled by a state agency. I believe it's the General Services Department. There's information on the web about that. I don't have that at hand, but it's a completely different process from the Surplus Land Act. On the question of schools, that's a complicated issue, and it's complicated because of legislation that just got passed as part of the budget trailer bill. So there have been exemptions in the Surplus Land Act for land that is disposed of consistent with certain provisions in the education code, particularly where that kind of is seen as superseding the Surplus Land Act. And there are provisions in the education code that allow school districts to dispose of their land, you know, in certain ways, but it required that it be done so consistent with any other laws, and that still required them to follow the Surplus Land Act when they were disposing of the land. But now there has been an amendment that has actually taken out one of the exemptions. So there was an exemption in there if school districts were disposing of land through what's known as the 7-Eleven process, where they work with a community-based committee to look into the uses of the land. That's no longer a basis for an exemption. So right now they would need to follow the Surplus Land Act. I don't think that would restrict them from saying we want this land to be used to house teachers and school district employees, for example. But under the SLA, they'd still have to make sure that at least 25% of that land was restricted for affordable housing. And I think there's, you know, a lot of work going on about trying to figure out ways that school districts are specifically permitted to see the development of that land for their own employees. I think if they are disposing of the land to a third party, you know, a nonprofit or for-profit developer under some agreement, that's clearly going to be seen as disposition and trigger the SLA. There might be a case to be made that if the school district is continuing to own the land and essentially is building the housing themselves, maybe contracting with someone to manage it, that might be considered agency's use if it's for their own employees. That's untested, so we don't know. But I know there are a lot of conversations going on about how to harmonize the SLA with the interest of school districts in providing, in particular, housing for teachers. So I don't know if that fully answers that question.
Not seeing anything else, I'm going to say, yes, I think that's a great answer to the question. And we're at time, we're at 2 o'clock. So I want to just thank everyone for coming. Thank you, Jeff and Tahirah. for the time and education and resources today. We've got some contact information up on the screen for folks looking to follow up with more questions. And that's the end of our Lunch and Learn today. So please come back for our September Lunch and Learn, and before then, our Faith and Justice Breakfast. Thanks so much, everybody.
So we'll just add, we will be posting the recording and the slideshow on our website within a few days. So if you wanted to follow up with that, you'll be able to do so.